rules of personal purity and conduct prescribed for admission to and worship in these religious places shall in no way discriminate against or impose any disability on any person on the ground that he belongs to impure or inferior caste or menial class. Which is, can I just elaborate on this? You can say that this is the acharam or the custom of this particular temple. But if you use birth-based restrictions to prevent access or entry, then that will certainly be in the teeth of the law, no matter what. And that is what translates to 25(2)(b). So while I'm not arguing the merits of the Sabarimala case, I'm just giving this by way of illustration that if the temple says because of the deity's Naishtika Brahmacharya character, there are certain proscriptions or prohibitions or restrictions on access to a particular class of people, which has got nothing to do with jati or caste in any way whatsoever, because that class is across castes as far as that restriction is concerned, then it doesn't run afoul of this prohibition. Therefore, I'll build this argument as I go along. Section and class are not to be treated as two different classes altogether. Class has been used consistently across the debate to refer to caste. Section has been used as a cross section within that particular class, or it can go beyond it, but it was always meant to have a caste-based connotation, not gender-based connotation, because if that happens, then religious diversity and rights under 26 can be easily defeated. Because there are temples on both sides, or even institutions on both sides across the board, where prohibition applies to people across genders. So for instance, there is this Artikal Bhagavati temple in Kerala, where access to men is restricted for specific reasons. I'd also given this example in 2018 in the first round. There is a temple in this district called Satabhaya in Odisha, where the priestesses are all of them are Dalits, and there's a reason for it. Apparently, the original Brahmin priest ended up seeing the deity in its unclothed form, and therefore, to atone for it, he decided to hand over the temple to 4 Dalit priestesses, and till date, for the last 400 years, the practice continues. The only time the practice was violated or breached in the recent past, perhaps around 2018-19, was because of rising sea levels. The Shivalingam had to be lifted heavily, or rather it has to be bodily lifted, and therefore men were allowed for the limited purpose. So what I'm trying to say is that rights under 25(2)(b) or the enabling power under 25(2)(b) has to be applied in a narrow sense. Otherwise, the purpose of carving out 26 will be completely defeated. I'm not making a policy argument. I'm making only a statutory argument in terms of what is the history. I'd only request my lords to kindly come to para number 20 at page number 13 for a moment. Following with the revisions which were proposed as far as clauses 16 and 17, kindly see in explanation 2, please see that is the second intended paragraph. Religious worship was substituted with religious practice. My lords, the Honorable Chief Justice sees that. So here, kindly see this. It says, all persons are equally entitled to freedom of conscience and right freely to so on and so forth, and other provisions of this chapter. And in that explanation 2, which is 25(2), for the words religious worship, practice shall be substituted. Therefore, financial, economic, political, or any other secular activity, previously it was associated with religious worship, it becomes religious practice. Then my lords may come to para number 21 for a moment, where I basically summarize the net result of the discussion on clause 16. Can I request my lords to kindly take a look at para 21 at page number 14.
Practice is broader than religious worship.
I'm so grateful. That was the intent, because otherwise it also limits rights under 25(1). And therefore it was meant to widen up the entire conversation, both on the 25(1) and 25(2).
So, and also it enables the state to make the law.
So grateful. That means
the law then.
I'm so grateful. That means the power of the state is not limited only to aspects of worship. It also extends to practice. I'm with my lady.
No, it doesn't extend to worship. It extends to practice.
Fair enough.
It is broad enough, but at the same time, it does not extend to worship should be the...
I stand corrected.
Yes.
Grateful. I'm grateful for the nuance. I didn't think of it that way. I'm grateful for it. Kindly take a look at para 21, and I request my lady to kindly see Romans 1, 2, 3, and 4 for a moment at page number 14. My Lord Justice Kumar has it, please. The term religious worship was replaced with religious practice in explanation 2. This explains the use of religious practice in 25(2)(a). Social reforms were made permissible with the consent of, kindly underscore the words, legislature. Which means this addresses one fundamental question across the board. Subject to clause under 25(1), enabling power under 25(2), subject to clause under 26 are powers to be exercised only by the legislature. Is a humble submission that all of that, which is why I think Mr. Gopal Shankaran said it is vertical in that sense, that the restrictions on those rights can be applied only by the state. And the state, my lady is aware, under Article 12 and 13, state does not include the judiciary in its judicial capacity. Mirajkar and several judgments have held to that effect. Therefore, for the purposes of this chapter or this part, the reference to state is to the executive and the legislature, and in my humble submission, it does not include the judiciary. Therefore, the question of entertaining any writ petitions challenging those practices on the ground that it violates any of those subjective provisions does not even arise, simply because those powers are limited to the state. And this perhaps could answer the question differently. I'm so sorry, my lady has something to say.
No, if the state, it enables the state to make laws.
Yes.
To bring in social reform,
Correct.
such as, for example, entry.
Correct.
Now, the question here is not, the controversy is not that the state has banned entry as such.
I understand.
State has made the law, rule,
So grateful.
act and the rule for entry.
I'm so grateful.
Under that, because of the custom, there is a prohibition.
So can I?
In the Kerala Act and rule.
My lady is correct. So here what I have done.
Made a law banning entry.
Please.
State has made a law promoting entry.
I'm so grateful.
But under the custom,
Yes.
there is under the 3B rule.
Yes.
There it is an exception.
So may I just respond to this? There are two specific portions of my written submission, both the old and the new, where I've specifically addressed this. And can I volunteer to respond to this before I continue with this? Because a question has arisen from the bench. Codification of a pre-existing religious practice by the state does not make that practice amenable to judicial review, because it is not exercise of rights under 25(1) or 25(2) where limitations are imposed. The submission is, if judiciary cannot or the courts cannot preside over constitutional challenges to practices themselves per se, merely because the state rolls that practice by way of a legislation, that doesn't make it amenable to review, is my humble submission. Because at the core of it, my lady would still be getting into the question of 25(1) and 25(2) in that sense.
In other words, whether the rationality of that custom can be questioned in a court of law.
I'm so grateful. That's the question. And if I may make this humble submission, I'm therefore applying the simple principle that what cannot be done directly can also not be done indirectly. So if you cannot get into the rationality of a religious practice, ipso facto, merely, my apologies.
My hit the basic structure.
May I answer the question?
Yes.
I'm so good.
You can say the role of the court is very restrictive.
I'm great.
A better argument.
I'm with my lords on the point, which is, in the process of entertaining those writ petitions to the challenge, again, ERP test cannot be applied, whichever way that route is, which is, the rewriting of the rules of religion would be beyond the scope of judicial review under Article 32 and 226 is my humble submission. Since the question of rationality was raised, I think Justice Banali had
Slightly different. But the moment you expand the wing of the state or the executive, the power of judicial review automatically comes.
I'm so
If
great.
the state in the name of social welfare,
Right.
suppose prohibits a religious practice,
Right.
who will examine?
I'm so great. Can I answer this question? When the state, I'll just show one thing. Can I request my lords to kindly come to that portion of my written submission where I've answered this question straight off? Can I finish this and come to that minutes? Just so that the flow is not broken.
That power of judicial review, there is no need to attack on that power so much.
Well,
That is, we understand that limitations are there.
please, minutes.
But to say that there is no power at all, it may also be very difficult to you.
No,
It's a very
I agree with
hypothetical
your
situation.
I
It will
completely
again depend upon
Please.
the situation. And
Can I perhaps request my lords